Greetings, everybody. Welcome to the 2021 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow, Director of the Environmental Law Center and Associate Dean for Environmental Programs at Vermont Law School. We're pleased to welcome viewers to our online presentation today. Each one of these talks in the series is worth one Vermont CLE credit. So if you'd like to get CLE credit for this talk, please keep track of your attendance for your records. We will have time for questions and answers after today's presentation, so please type any questions that you have in the chat box at any point during the lecture, and we'll get to as many as we can in the remaining time. Today, we are very pleased to welcome our own Jim Murphy and Mason Overstreet. Jim Murphy is the director of our Environmental Advocacy Clinic at Vermont Law School. He joined the clinic and the faculty at VLS in 2019, and he also serves as the legal advocacy director at the National Wildlife Federation. Jim has focused his work on legal engagement on behalf of people, places, and wildlife with the judicial, administrative, and legislative branches of government with a focus on energy, climate, and water issues. He has represented National Wildlife Federation and other conservation groups as parties or amici in several precedent-setting cases before the U.S. Supreme Court and federal circuit courts. Mason Overstreet is a staff attorney and assistant professor of law in the Environmental Advocacy Clinic. His work ranges from issues involving water, pesticides, toxics, endangered species, climate change, and public lands. And before joining the clinic as a staff attorney, he was an LLM Toxics Fellow in the clinic. Today, Jim and Mason will present a talk titled The Forest for the Trees, Short-Circuiting Environmental Review for National Forest Cuts. Please join me in welcoming Jim and Mason.
Great, thank you. And we are going to do a PowerPoint, which I think for most of our presentation will mean that you'll be looking at the PowerPoint instead of us, which might be a good thing for, well, at least on my behalf, good thing for everybody. By Mason, maybe not. So I'm going to share the screen, and then we can delve into the topic, which has both national implications, but also implications here in Vermont, as we're going to describe. As we were brought to this subject actually through a proposed cut down in southern Vermont, and we can explain that. But so I'm going to share my screen now, and then we can delve in. Great. So I'm assuming that's up on the screen. Today's topic is condition-based management, and how did we get involved in this topic? Back in 2018, there was a proposal on the Green Mountain National Forest down in southern Vermont, in an area that encompasses the White Rocks National Recreation Area. It's where the Appalachian Trail and Long Trail come together. It's the section, if you know Vermont, kind of if you're driving down Route 7 between Rutland and Manchester, it's that very nice area along that stretch to the east of Route 7. There's a couple wilderness areas in there. There's some wonderful stream resources. But the Green Mountain National Forest put forth a proposal to create early successional habitat. And just to give a little history of the forest, the Green Mountain National Forest and forests of Vermont generally have been clear-cut multiple times over their history, or at least since European settlement. And as a result, since a lot of these cuts were pretty massive and within a short period of time, while Vermont is a very heavily forested state, it's the second most forested state in the nation, most of the forest area in Vermont is what's called even age, meaning that most of the trees are of a relatively similar age because of these cuts, and as a result, when you have a similar aged forest area, you don't get necessarily immense diversity in habitat. So the project's goal, at least on its face, was to do some cutting on a 17,000 acre area in the area I just described, cutting about 15,000 of those acres over 15 years with the idea that these cuts would create a mix of habitat by allowing new growth to occur, at kind of various stages over these 15 years. The clients we represented, Vermont Natural Resources Council and National Audubon's Vermont chapter, supported this project in its aim. They agreed that Vermont could definitely benefit from a mix of habitats, and that the goal of creating more diverse habitats would increase habitats and increase species and the ability of certain species to thrive. And one of the main targets was essentially songbirds. With neotropical passerines is the term, but it's basically the type of warblers and whatnot that you often see in the woods. The problem with this project, when we looked at the way they proposed it, was they did the environmental analysis using an approach called condition-based management, which we're going to talk much more deeply over the course of this discussion. But condition-based management is basically a trust me approach. It said, as we cut over these 15 years, we're not going to give site-specific information about when we're going to cut, where we're going to cut, when we're going to build roads, where we're going to build roads, what those roads are going to look like, what habitat they're going to affect. We're going to kind of have a menu of treatments that we will apply on a cut-by-cut basis over this 15-year period. And this menu of treatment should take care of environmental concerns. The problem with that, obviously, is over these 15 years, as they apply these treatments to various cuts, there's no opportunity for public review of those cuts. There's no opportunity for public engagement. And also, some of the numbers are pretty staggering for this project. This is one of the largest proposed cuts in the history of the Green Mountain National Forest. It covers about 4% of the forest area. It originally proposed 25 miles of new permanent roads, where the forest plan, the applicable forest plan, contemplated about 5 miles of permanent roads for the entire Green Mountain National Forest over this period. It would have been a 41% increase in permanent roads in this area of the forest. And then there's some other concerns. I mean, there's, as I stated, a couple wilderness areas, some kind of key brooks. There's some great brook trout habitat. There is both very rich bear habitat and also corridors. So the specifics about how this project was going to occur became very important. Where they were going to cut, when they were going to cut, how they were going to cut, all really went to the questions of, is this going to be a responsible project that has overall habitat benefits, that is going to protect species, or is this going to be a free-for-all on a gorgeous piece of the forest, an important piece of the forest, where harvesting concerns are going to take precedent over habitat and natural resources concerns. So that's kind of where we came into the project, project with a purpose that actually our client supported and appeared laudable, at least from a forest management perspective, but with a process that left a lot to be desired. So I'll turn over to Mason to talk more about condition-based management.
Thanks, Jim. We can go to the next slide. So as Jim mentioned, so for this talk, we're primarily going to be speaking about condition-based management, right? But we're going to be using the project that Jim just spoke about. Environmental lawyers, we all love acronyms, and so we're going to call it's the ESHC project, Early Successional Habitat Creation Project in Green Mountain National Forest. But we're going to use that because it really provides a wonderful lens and case study to look at the larger topic. So Jim, let's go next slide really quickly. Okay, so let's talk a little bit about what condition-based management is. Jim mentioned some and kind of did a 30,000-foot flyover. So CBM, again, environmental lawyers love acronyms, we'll call it CBM. It's a management approach that the Forest Service is using increasingly across the country with timber harvest. And the goal and rationale for the Forest Service for the use of CBM is really increasing flexibility, discretion, and efficiency with project planning, analysis, and implementation, right? And so the rationale is that flexibility is needed with many of these long-term projects. When Jim mentioned the ESHC project here in Vermont, that's a 15-year project. We'll talk about some others that also, span several decades. And so the agency's rationale is that it needs flexibility because conditions on the ground can change quicker than decisions can be implemented under the current environmental and administrative review process, okay? And so CBM projects, when Jim mentioned kind of the use of a menu, it's a good analogy because basically what happens is CBM projects use an overarching set of goal variables, okay? So those are predetermined management criteria that guide implementation. And what happens is Forest Service staff apply that menu, right? Those goal variables to on-the-ground natural resource conditions encountered during the course of project implementation, which I mentioned a few seconds ago. That can be several years, but it can also be several decades, okay? And so put another way, when the Forest Service finds X resource condition on the ground, it applies Y timber harvest prescription. The problem here, which Jim previously touched on and is helpful, is that basic information regarding the project's details, such as unit location, timing, road building, road locations, harvesting methods, harvesting locations, and other site-specific environmental effects, those are not necessarily always provided at the time the Forest Service conducts its environmental review under the National Environmental Policy Act, NEPA, right? That's when the public can weigh in, and nor are those site-specific environmental effects provided when the agency, the Forest Service, gives its final approval to a project. That's when the public can seek administrative review, okay? So instead, under the CBM approach, site-level disclosures, they're made after NEPA environmental administrative review is complete. So that effectively deprives the public of opportunity to comment, but importantly, it deprives the public the opportunity to influence the decision based on localized conditions. Jim laid out the ESHC project here in Vermont, but again, using that as a lens. So the location, Jim mentioned that there was 25 miles of proposed road construction. The location of those roads was not disclosed in the environmental documents and the environmental review, which was an environmental assessment, right? Nor were the specific locations of some of the cuts disclosed. So that deprived the public an opportunity to weigh in on the effects of what would be some of the issues associated with road construction and timber harvest. So to kind of wrap things up, before we go any further, you've probably noticed we've already gone into the deep end as far as with NEPA, the relationship with the National Environmental Policy Act, NEPA's environmental review role with CBM in U.S. Forest Service projects. So Jim is going to provide kind of a 30,000 foot flyover review refresher on NEPA quickly. Jim?
Yeah, and I mean, one of the justifications that the Forest Service has, and this might be reiterating some of what Mason said, has given for CBM is as a compliance for NEPA, because NEPA is really the grandmother of environmental laws. It was passed in 1969, signed into law early in 1970 by Richard Nixon. It was really kind of the first of all of the major environmental laws passed in the early 70s through, really, CERCLA kind of being the last one in, I think, 1980. And it requires all federal agencies to examine the environmental impacts of major federal actions. It's a look before you leak statute that courts have said requires that agencies take a hard look at the environmental impacts of their actions. And this has, historically included a really broad look at environmental impacts, including the direct impacts, as well as indirect impacts and cumulative impacts of the project itself, plus other reasonably foreseeable projects that are both under the responsibility of the federal agency and otherwise on the landscape by private actors, to really understand what the full scopes of the impacts will be on the environment. A little side note, as those of you who have followed the disaster on the environment that was the Trump administration probably know, the NEPA regulations, which have been in place since 1978, took a big hit in 2020, and a lot of the substantial requirements for review under NEPA have been undermined by a 2020 rule that the Trump administration put into place. And there's a lot of debate right now about how much of that rule is illegal. We think it's a lot, but so NEPA is under attack. It's been under attack in the Trump administration, and it's also, I think, been improperly labeled as something that's made it difficult for agencies to comply with fast-moving conditions on the landscape, which is where CBM came in. But one of the primary things that NEPA has always really required has been site-specific analysis of projects. So that way, one of the big purposes of NEPA, which is giving the public the ability to participate in the process and to give input in the process, without site-specific information, courts have historically said that a NEPA review is inadequate because it's very hard for the public to understand the impacts of a project and to comment on the impacts of a project. And I think this is at play with the early successional habitat creation project that we were looking at. Where those 25 miles of roads are going to be built, how they're going to be built, how they're going to limit access to other uses, et cetera. What sort of habitats they may fragment. These are all really important questions that allow the public to understand or not understand what the environmental impacts are. So the main lens that CBM is coming through has been NEPA. And again, the Forest Service has basically said that this kind of treatment approach will deal with it as it comes. Trust us, if we use these approaches, the environmental impacts will be taken care of. It's definitely an attempt to skirt this more searching review that has historically been both conducted by the Forest Service under NEPA and required by the courts under NEPA. back to Mason for a history of CBM.
Thanks, Jim. So let's quickly talk about just basically the history of CBM and when it came about. To many surprise, CBM, it's not a new management tool. So interestingly, the Forest Service has employed it for over a decade. It was used sparingly during the Obama administration. And however, you know, its use accelerated during the Trump administration. And currently, there's no sign of its use slowing. You know, generalizing and speculating a little, Jim alluded to this some, you know, in line with some of the Trump administration's rhetoric against environmental regulation and environmental and administrative review, you know, we can speculate and generalize that the Trump administration saw CBM and jumped onto it as something because it effectively circumvents the NEPA process and environmental review process that Jim just spoke about. The point here is that to date, there's a host of Forest Service projects across the country that have used and are using CBM. You know, again, using our Vermont example of the ESHC project, that project was the first CBM project to date in New England. Currently, there haven't been any other projects proposed with CBM in White Mountain National Forest or Green Mountain National Forest aside from the ESHC project. So the slide you're looking at now, this is just something that Jim and I wanted to provide to all of you because it gives you an idea of examples of past and current projects that use CBM or have CBM components. And interestingly, something kind of a common thread, if you go back to what we were discussing a few minutes ago about the rationale for the use of CBM, and if we had the time to actually go down and explain each one of these projects, you would see the need because most of these projects have a longer duration, right? So they're, you know, 10 to 15 years, right? But they also, you can see the need and desire for some of these projects for flexibility, okay? All right, well, Jim, I think now what we can do is we will dive into kind of concerns about CBM's legality and where it stands. And Jim's going to do a deeper dive a little bit into NEPA again.
Yeah, and I think the biggest concern that public lands advocates and natural resources advocates have with CBM is that it fundamentally violates NEPA's mandates that agencies take a hard look at their actions before a project commences. And I think paired with this is also a real deep concern that it undermines the public participation and public input component of NEPA. Without site-specific information up front that allows frankly the agency, sister agencies that also have jurisdiction over this project. And we're going to talk about some problems with the Endangered Species Act consultation as well, and the public being able to understand the specifics of a project, particularly on a complex landscape like a forest. It becomes, again, and I've used this term many times, a trust us approach. I think the Early Successional Habitat Creation Project, again, is a great example, and we keep coming back to it. One, because it's how we got introduced to this, but two, I'm thinking that most of the people on the presentation right now are from Vermont and know Vermont's forests. When you're talking about harvest impacts on a forest, and a lot of us have been out and seen what these look like, the specifics are really, really important. Where a road is going to be built, what's going to be cut, for instance, when you're talking about bear habitat, the CBM approach to bear habitat was, if we find a problem over this 15-year period with bears, we're just going to consult with the experts at ANR and assume that it's going to be fine. Well, if you're a member of the public, how do you respond to that? Yeah. For one, that's going to occur at an undetermined point in the future. Two, it's going to occur without any public process. So, so if they hit, for instance, a rich beach stand, that could be very valuable either to bear migration or to the bear population in the area. What's that cut going to look like? And the only thing that you're being told is that there's going to be some sort of communication between the Forest Service and ANR. But again, you don't know which beach stands might be affected. You don't know what the type of cut on that beach stand is going to be. Is it going to be a clear cut? Is it going to be more of a select cut? You don't know if there's going to be a road that's going to cut right through that, or maybe the road will be far from that. You don't know what sort of specific mitigating measures might be put in place to, say, protect migration corridors, to limit access on a road if there is a road nearby. What's the road going to look like? Is that road suddenly going to become a magnet for other uses that could prevent, or that could could add harm to the bears or to other species there? So all of that information is essentially taken away from the public, and the only thing the public is left to comment on is this vague promise by the Forest Service that at some point, if we have some sort of bear problem, we're going to consult with ANR. We're not going to tell you about it at the time. You're not going to be able to make specific comments on that cut at the time. You're not going to be able to make specific comments on that road at the time. You may not even necessarily know about it. So that alone completely undermines the hard look component of NEPA. And in the process also takes away that ability of the public to really engage meaningfully with the agency and ensure that the project is going to meet the purpose and need it set out to, which is to responsibly create early successional habitat, rather than perhaps be an excuse, and this was certainly, I think, a concern in the Trump administration, to meet certain harvesting or other quotas. So that level of public engagement, that level of upfront analysis, transparency, et cetera, was all removed. And I think it's worth stating that NEPA has been a very successful tool in helping really make forest cuts much more responsible. About 1 in 5 acres of proposed cuts end up being in some way changed or revised, largely based on the public input that comes with that upfront process. So when you're talking about a process that results in at least 20% of the project changing due to public input, due to informed public input, because the public can see the site-specific impacts and comment on that. When you take that ability away, you're almost necessarily putting the resource at higher risk. Obviously, the last point, we feel CBM is fundamentally illegal. It violates NEPA in most instances. But we certainly feel that to the extent that the practice might be legal, it should be minimized and used in very rare circumstances. There's 2 major cases that deal with NEPA, and Mason is going to tell you about them. And then there's also, I think, worth mentioning a Vermont case pre-CBM that I think it gives a little contrast to how CBM works. So Mason, dive into the case law.
Oh, perfect. Thanks, Jim. Yeah, so as Jim mentioned, interestingly, there are two primary cases, which we're going to debrief quickly, that where CBM was involved, okay? And the first of those cases is a 10th Circuit case decided in 2019. It's called Wild Earth Guardians v. Conor. We're going to call it Conor. And there, the 10th Circuit approved a CBM approach for a logging project, which took place in southern Colorado. And importantly, we're going to dive into the specifics in a second, but importantly, it was in Canada lynx habitat, okay? And so as we walk through this, you should be thinking about how this differentiates from other projects, including the one that we continue to mention here in Vermont. But so the project in Conor was a response to a mountain pine beetle epidemic that impacted forest stands in the White River and San Isabel National Forest. Like the project here in Vermont, again, it was a 10 to 15-year project, okay? It was intended to create forest conditions that provided more resiliency for outbreaks of insects, disease, wildfires, and also as well as improve wildlife habitat. Planned actions under the project there in Colorado involved clear cutting, thinning, and prescribed burns. And importantly, so there was an environmental assessment. Similar in Vermont with the ESHC project, you have an environmental assessment too versus an EIS, an environmental impact statement. In the case in Conor, there was an environmental assessment at issue, and it utilized CBM. And specifically in the EA analyzed three alternatives, okay? One of those alternatives was a worst case scenario alternative, and that analyzed the project's effects on the Canada lynx, which I just mentioned a few seconds ago, as well as other things. But it's important to key in on the worst case scenario issue here, okay? And so the Forest Service, under the worst case scenario, basically said, okay, we're going to assume here that the entire project area that we're looking at will be clear cut. And then we're going to look at the effects on the Canada lynx, right? So that was how the worst case scenario went. So the Forest Service and the court size, they took that conservative approach. And it's important because they didn't know via CBM basically precisely where they would be logging in the Canada lynx habitats, okay? Kind of jumping back, but so the EA, the environmental assessment in Conor, it quantified the amount of treatment, but it never specified the actual treatment locations. Very similar to the situation in Vermont, the ESHC project, okay? And so again, you can see that when we're thinking like, larger picture about CBM, you can see that aspect and desire for flexibility and responding to on-the-ground changes, changing on-the-ground conditions, right? So going back to the court's analysis, basically, based on the conservative approach, right, looking at it, the entire project area as under a worst-case scenario approach, if it were clear-cut, and the effects on the lynx and other things, basically, the court determined that site-specific choices weren't material to the effects on the lynx. So that's important. It's really important to kind of distinguish that. The court basically said, because the site-specific choices weren't material to the effects on the lynx, it was okay, right? So put another way, it didn't matter where the logging occurred because there wouldn't be a negative effect on the lynx, right? Okay, so zooming out with Conor, public land advocates working on CBM, they've thought about this case long and hard and looked at the opinion. And to kind of tie it up in a bow for all of you, the takeaway for Jim and me really is that, again, the court agreed that it didn't matter where was cut because there would be no effect on the lynx via the conservative worst case scenario approach. So in other words, site-specific choices weren't consequential for the links issue. Okay, so that's in contrast to the case that we'll dive into momentarily, where there were lots of ways that site-specific choices would have been consequential. Okay, so Jim, we can go to the next slide. So this is the second case, right? And it's called Southeast Alaska Conservation Council. Again, just using the acronym to make it easy, we'll call it SEAC. To zoom out before we zoom in and kind of compare it a little bit to Conor and what the court said. So when you look at this case and the project involved in this case, which was the Prince of Wales Landscape Level Analysis Project, there's a few things to key in on. One is the size and scope, okay? Though it had a similar duration, the project here in SEAC was a 15-year project, which again is very comparable and similar to the ESHC project in Vermont, as well as Conor in Colorado. A difference is that while Conor was relatively similar in size to the ESHC project in Vermont, the Prince of Wales project in SEAC was much larger. Okay, so the Tongass National Forest, it's the nation's largest national forest, 16.7 million acres in southern Alaska. This specific project took place on the Prince of Wales Island within the Tongass. Okay, so to zoom in a little bit more, just comparing and contrasting, the SEAC case and the SEAC project, the Prince of Wales Landscape Level Analysis Project, it involved an EIS, okay, so an environmental impact statement versus an EA. So Conor and the ESHC project in Vermont both have EAs. SEAC involves an EIS. That's something to kind of key in on. Activities in the SEAC project involve vegetation management, timber harvesting, watershed improvement, sustainable recreation management, et cetera. But primarily what we're focused on here with this case is the timber harvesting. Okay, so let's just pause for a second. I want to mention something that Jim and I are going to go into in a little bit that's probably rolling around in your minds right now. Typically and generally speaking, okay, because of the size and duration of a project like SEAC, usually, right, and again, we're generalizing here, but usually there would have been a programmatic environmental impact statement. We'll kind of call that an umbrella environmental impact statement. In the site-specific cut actions at later dates, right, those would have included subsequent EAs, environmental assessments, that tier back to the original EIS. The key point there is that public comment and public opportunity to get involved in the decision making is allowed throughout the process, right? And from beginning to end, starting with the programmatic EIS and going into the site-specific cut actions, which would have EAs. That's not the case here in Tongass. Okay, so let's go back to SEAC. So that was not the case. There was simply an EIS, and under the EIS, well, the project would have authorized logging on more than 40,000 acres, 24,000 acres of old growth forest that hadn't been cut. And, importantly, there was 643 miles of new and temporary road construction. But the issue in SEAC was that the EIS never included a determination or even an estimate of when and where harvest activities or logging would occur, and when and where road construction would actually occur, right? So so the public, back to some points that Jim made earlier, the public knew that there was going to be 643 miles of roads, but they didn't know when and where those would be, and they weren't able to comment or provide feedback on that. Okay, so here in this case, the court in SEAC, District Court in Alaska, right, so not an appellate court, it found that the analysis in the EIS was not specific enough. And because, right, it excluded information about harvest locations, methods, and localized impacts. Importantly, too, while you're thinking about Conor compared to this case, is that the court further held and said that a worst case analysis could not save the project because the site-specific differences were consequential, okay? So just quickly, zooming out a little, now that we've looked at both of these cases, when you read both of them narrowly and you look at Conor and SEAC together and put them side by side, Conor arguably is really totally consistent with a proper understanding of NEPA. And arguably it stands for the proposition that CBM can't, and I'm saying this is arguably, different people have different opinions on this, but arguably Conor stands for the proposition that CBM can be done lawfully. SEAC, however, stands for the proposition that it's really hard to do lawfully. And arguably, in fact, it's really nearly impossible to do for large-scale commercial harvest, right? And the final point that I'll say is that related to Conor, if other site-specific differences had been at issue in Conor, presumably, and we're speculating here, Jim and I are speculating, but that case could have turned out differently, okay? So Jim, back to you to talk about the ESA.
Yeah, and just a couple of quick thoughts on kind of Conor v. SEAC. I think one kind of factual distinguishment in Conor v. SEAC, and there's some odd language in SEAC that I wonder if it would really stand the test about the kind of the difference between Conor being an EA and SEAC being an EIS, and almost an implication that the agency will get more scrutiny for doing a more thorough analysis than if it did a less thorough analysis, which I think was a bit of a way for the judge to navigate a tricky situation. But I'm not sure it's something that is going to be a lasting proposition. But if you kind of look at the facts, with Conor, you had a much smaller cut, and the analysis kind of covered the even though it wasn't site specific, it covered the universe of choices that related to the specific impacts it had to a specific species. So, the court was really able to say, the agency, while it didn't do a site specific analysis, it essentially covered all of the potential impacts to the species and found that it was still not significant. With SEAC, as you're seeing, you have not just a much larger area, but within that area, a lot less information about what those impacts are actually going to be. You've got a smaller cut area, you've got a lot of roads that could go in a variety of places. So, so the more that's unanswered by the process, the less CBM is going to be legal. And then I just want to throw out there for people who might have a bit of a history on, the Green Mountain National Forest, unlike Forests Out West, is not a place where there's been heavy litigation. But, in a case back in the 90s, the Second Circuit ruled that with an EA on a cut down in the Lamb Brook area, that not having specificity on just slightly over a mile worth of road in terms of the mitigation measures, the precise location, et cetera, that that was enough to create an inadequate NEPA process. And here you've got a situation where they're trying to use CBM for 25 miles with very little detail. So I think it's both a testament as to how NEPA law has evolved to be looser, but also just what the Forest Service is trying to, or was trying to get away with in terms of not having a specific NEPA process. The same issues that create, I think, problems with NEPA also create problems with the Endangered Species Act. There were a few listed species, one in particular, the Indiana bat, that was really impacted or potentially impacted by the early successional habitat creation project. And again, details matter. The Indiana bat was or is a species that that does not exist at higher elevations, is not likely to be present a certain distance from certain vernaculums. So when kind of evaluating whether because under Section A2 of the ESA, all federal agencies, before they take action, need to consult with one of two federal wildlife agencies, either the Fish and Wildlife Service for terrestrial creatures or the National Marine Fisheries Service for marine species, to ensure that the project is not either going to likely jeopardize the species or adversely modify or destroy critical habitat. So some key things to note there. One, again, this has to occur before an action takes place. And then there also, obviously has to be a determination that it's not going to jeopardize, or if there is jeopardy, there has to be steps to be taken to ensure the species is protected. So when you're talking about, a 15-year cut over 15,000 acres, some of which is potential habitat for the Indiana bat, some of which is not, the ability for the Fish and Wildlife Service to make a determination in conjunction with the acting agency that there's not going to be jeopardy, and for Fish and Wildlife Service to concur with that and to understand it, is almost impossible. Because if you avoid certain areas, there's a good argument the species will be fine. If you don't avoid areas, there could be jeopardy to the species. And if your approach under CBDM is we're not going to disclose that information until down the road, so maybe a year 11 they do a cut that is in Indiana bat habitat, but that's not disclosed in year 1. The Fish and Wildlife Service, at least under our reading of the law, effectively cannot both the agency, the Forest Service, and Fish and Wildlife Service cannot come to the conclusion and concur the conclusion that jeopardy will not occur. And as has been stressed in case law, it's an old case, but it's still good law, they can't do a segmenting approach. The consultation has to occur up front. It can't occur cut by cut, which is how the Forest Service was proposing to get around that. So, so CBM creates not just a NEPA problem, it also creates an ESA problem. So back to Mason for alternative and solution, and I know that we are 10 minutes out, so we will try to wrap up these next slides quickly so we can have some Q&A.
Perfect, Jim. Yeah, thanks. Since I already mentioned and alluded to this point, but so I'll cover it pretty quickly. But in our opinion, CBM is not only legally questionable, but it's really unnecessary. And specifically, the Forest Service already has NEPA compliant methods to deal with some of these situations that require this kind of so-called flexible, nimble response to the needs of dynamic landscape changes on the ground, right? And so going one step further, the Forest Service can complete a single programmatic analysis. When I was talking about SEAC, I just mentioned this in passing, but so the process that's already in place is that the Forest Service can use a single programmatic analysis to which future site-specific decisions can be tiered back, okay? And that allows for the Forest Service to kind of speed the consideration and implementation of site-specific step-down proposals, but importantly, it allows the public the opportunity to provide comment and input on site-specific decision-making and environmental and administrative review throughout the entire process, right? And this gets at the intent and essence of NEPA, which Jim discussed. Jim?
Yeah, and so surveying the regulatory horizon, yeah, I mean, I think it's important to note that we are at a crossroads. When you use crossroads in terms of forest management and the problems that they're faces, and it's the challenge that I think we're facing across the environmental spectrum with climate change really presenting new and different problems than we've had before. Insect and forest petulance, changes in temperature, changes in when species arrive and when species emerge, changes in drought and rainfall conditions have all put immense pressures on our forests. And we're seeing it in the east, definitely, but right now, as we just have horrible forest wildfire season after forest wildfire season out west, with each one breaking new records, there are challenges right now facing our forests that I think have to be acknowledged in terms of their scope and intensity that are just we haven't seen them in the past. These are not the same forests that were being managed when NEPA was passed. And then I think there's challenges on the agencies too, with restrictions in budget and staffing. I think made worse by some starvation during some recent administrations, including the last one, that have never really been fully restored. So the Trump administration tried to codify CBM into its NEPA regulations. It did not. We're not quite sure why. Part of the reason might be some of the skepticism that the SEAC court and some others drew towards it. There's also some, forests are not the only landscape out there that are facing these challenges, both in terms of climate change and development and other new pressures, but also restrictions on agency resources. So agencies like BLM have started to use CBM equivalents in NEPA-related planning documents. CEQ has yet to weigh in on CBM. Again, it's nowhere been codified in the regs, including the CEQ's 2020 regs. But this is obviously something that this new Biden administration needs to think hard about. How to preserve NEPA's hard luck standard, how to ensure that public participation occurs in a meaningful way, and frankly, how to responsibly manage resources like forests in a time of climate change and in a time of unprecedented changes on the landscape and challenges. So I think with that we can have questions. And again, sorry we went long, but hopefully we can get all the questions in. And I will stop sharing my screen. So
thank you both so much. We do have a few minutes for questions from the audience, and if you're watching on the website live stream, just click on watch on live stream and on that icon at the bottom of the video, and that'll bring up the chat box. Or if you're watching on Facebook live stream, add your question to the comment box below. So first question, you provided a list at the beginning of the talk that showed a number of projects where condition-based management had been used, and the list for the western mountain area it looked like 4 or 5 times as long as the one for out east. Is that just because there's more forestry projects out west, or is there something about that geography or politics that has led to that kind of management out west?
Jim, do you want to take that?
I can start with it. I think there's just a lot more national forest out west. It's managed, I think, much more intensively and harvested much more intensively than in the east. And I think some of the challenges they're facing are a little harder and more immediate than they are in the east. For instance, the pine beetle infestation has radically changed some forests along in the interior Mountain West, and the wildfires. We're just not having the wildfires and the urgency around that they're having out west. So I think just the disproportionate amount of land coupled with more urgent challenges, and I think a history of heavier management and more intensive logging have resulted in that.
Okay. You talked a lot about informed public input and the ways in which condition-based management doesn't really allow for the public input that NEPA envisions. But the details of site-specific forest management seem as though that might require an amount of skill that your average member of the public wouldn't have to be able to assess whether a plan that's being put in front of them really is adequately protective. So is there generally meaningful public input into these processes, and how does your average member of the public understand how to give that input?
I mean, I can take that one again. I think yes, there's incredible meaningful public input, and these plans change oftentimes substantially as a result of it. There are a lot of groups. I mean, in Vermont, there's VNRC, Conservation Law Foundation, Vermont Audubon, all have extensive expertise in forest management. And the ability to look at some of these plans and give detailed technical comments on them, and then don't dismiss the value of the more recreational user. A lot of people spend time in the forest. They understand these lands. They can look at a map and see, boy, you build a road next to this brook, and my brook trout go away. Those can be really, really valuable as well. So yes, it can make huge changes, and there's varying levels of expertise, obviously, in the public, but both the technical expertise that comes in, as well as the more anecdotal or more kind of on the ground user input, both of which can have an immense effect in changing how these projects work.
And in case anybody's listening.
Oh, Jenny, go ahead, and then I'll add just something quickly.
I was just going to say, maybe for anybody who's listening that would like to know how they would go about providing that public input, you could just provide some suggestions for how they would do that.
Oh, absolutely. We'd be happy to. Yeah, I completely agree with what Jim said and think he covered it. The only thing I'll add, Jenny, is that, even the inexperienced, comment writer, say, like Jim mentioned, the hiker, the angler in Green Mountain National Forest that may not have that true comment skill set, they still can apply. I mean, I think that person can read an environmental assessment and notice that 25 plus miles, again, in the example of Vermont, of road construction was not disclosed, and they can match those two up and also want to know the impacts of those 25 miles, right? So.
Okay, great, thank you. We are at 1 o'clock, so I think we need to wrap up the talk for today. Thank you so much, Jim and Mason, for that presentation. And I also want to thank Emily Potts, our multimedia production manager. This is her last hot topic that she's producing and recording for us. Emily is going to be moving on from BLS, and I just can't overstate what an asset she has been to the school. We owe the smoothness and quality of these presentations in large part to her, also to Courtney Collins at the ELC. So Emily, we'll miss you, and thank you so much for everything you've done. And for our viewers joining us today, our next Hot Topics talk will take place here on June 10th at noon Eastern Time, and we hope you can join us then. Thanks, everyone.
Thank you.
Thanks so much. Bye.